right, we have our second case of the morning now. It's 25-1361. Lufsey?
Lufsey, yes, sir.
Lufsey versus Lufsey, now known as Tolfa. Okay, ready. All right, counsel, if you want something other than 5 minutes for rebuttal, let us know.
6 minutes, please,
6
Your Honor.
minutes, you got it. And on the little traffic lights you have there, green means you're in your original time, yellow means you're into your rebuttal time, and red means it's time to sit down. 20 minutes on the clock is your total time.
Thank you, Your Honor.
With that,
With the permission of the court, because I know you asked the first appellant to explain a little bit about the case, I'll do that. I know it comes out of my time. That's not a
that's
problem.
okay, we'll give you a minute to lay it out, a minute or two to lay it out, just very vanilla.
Right.
Okay,
I represent the father in a, I don't know, you want me
go
to?
ahead and turn to that for this.
I represent the father in a post-dissolution action. Actually, it is the 5th post-dissolution action. He filed for divorce and mother kept coming back to court. And we've got a judgment in this 6th round of litigation that we have appealed. The trial judge terminated his right to have decision-making in the child's education as well as over her health care. And that's what we're appealing to this court.
All right, thank you. Nicely done.
Thank you, Your Honor. May it please the court, I know kind of repetitious, but I'm Ted Green and I represent the appellant father. We have essentially one central issue that's on appeal, but it breaks out in 3 different ways. Our argument is that my client was denied due process at the trial level. I mentioned, talking to the audience, that this was the 6th round of litigation. As I point out in my brief, we contend that the error starts in round 5. The parties have never agreed about anything, including education and healthcare. Education and healthcare have been litigated in every round up to this point. And yet, the 16-year-old daughter is healthy. You'll see in the record that the worst that he's not a psychologist. The judge wouldn't allow a psychologist to examine the child. I'll come to that in a moment. But Dr. Pittington, the worst he could find is that she is aligned with the father in terms of his views, and I'll come back to that in a moment too, and that she has mild anxiety. Mild anxiety, as if she would be the only 16-year-old to have that. As you know, the requirement for modification by itself as a baseline would be a substantial change in circumstances that could not have been anticipated at the time the last judgment was entered. That plays into this as well. And that there's been a provable detriment to the child. And I use the term provable. We talk about evidence in court, but there are plenty of cases that say it has to be an evidentiary foundation that the child is actually suffering a substantial detriment. And that just is not here. Stepping back a bit, they've litigated these issues, healthcare and education, every single time mom came back to court. Round 5, where I contend the error began, was in COVID. COVID divided this country. It also divided this ex-couple, this former couple. Mom was afraid, and I try to use that term. I try to be generous with the other side as well as my own. Mom was panicked that this was going to kill her daughter, and she wanted her daughter to wear a mask and be vaccinated. And Dad had a different opinion. His opinion was this probably isn't going to be as severe as most people are thinking. My daughter already has anxiety. I don't want a mask on her because that would exacerbate her anxiety. So he opposed that. Mom filed an enforcement action. That was round 5. That was litigated to conclusion on an evidentiary basis. On November, there was a hearing in November, I believe it was 23. My date might be off, but I think it was November 2nd or 2023. They litigated the mask issue. And the trial judge found that mom had not met her evidentiary burden to require the child to be masked. They had the next month another evidentiary hearing where they litigated the issue of COVID vaccine. And mom found that, the trial judge found that mom had not met her evidentiary burden. And in that case, Dad had an immunology and virology expert who said that Dad's concerns are medically well-founded. This is a new vaccine. We don't know what the results of it are going to be. And it appears that COVID itself poses fewer potential risks than the vaccine does. Mom brought a doctor, but all that doctor testified to was that the daughter is eligible for the vaccine. So the trial judge ruled in father's favor. However, this was my view. I don't think the trial judge liked that, and I make this argument in my brief, because while she ruled in favor of father, she left the door open for mother. She told mother, if you come back and retroactively move to strike Dad's expert, you may get what you want.
How long before this hearing was your expert disclosed?
I believe, because I wasn't the trial attorney at the time, I was trial and appellate counsel now, I believe he was disclosed 2 days before the hearing.
Okay, that's typically experts are disclosed more than 2 days before a hearing, aren't they?
They are, however, there was no order in place requiring a disclosure date, and there usually is when evidentiary hearings are set. And I say evidentiary hearings.
Is it within the trial judge's discretion to allow when I say your expert, you want the trial counsel, so we won't have to go back and figure out who was the lawyer for your client at the time, but to allow your expert, father's expert, to testify, but since it was a short time before and the mother didn't have a chance to get a deposition necessarily before I got, okay, we'll take the testimony, but then, if you're harmed by this and need to go into the witness's background more, you can. I mean, that's within a judge's discretion, isn't it?
Well, first of all, that's not what the judge ruled. So even if it's a discretionary matter, even if it's a discretion, the trial court has some discretion. This court, and I don't recall the site off the top of my head, this court has ruled that there's a three-pronged analysis that a trial judge has to go through if they're going to strike a witness. And one of the things they have to consider is, could we address this with a continuance? Mom did not move for a continuance. So there was no order setting a disclosure deadline. And by the way, the hearings were set in short order anyway. In fact, one of them, father asked for continuance on, and mother opposed it. Mother never asked to depose the father's expert. The judge never ordered that there should be a deposition. The judge never ordered that there was any impropriety in a disclosure 2 days prior. And the judge allowed the testimony and based her ruling on the fact that Dad's expert was an immunology and virology expert.
Was this testimony ever stricken?
No.
So you're saying that your view of things is by the judge stating in her order that she could come back and the wife could come back and make this motion, you're saying that harmed your client in some way?
I'm saying that is evidence that the judge was biased, and bias is part of the due process argument.
Okay, but your witness was never stricken, his testimony was allowed, and the judge ruled in your client's favor based apparently on that expert witness's testimony.
That's right, but the judgment that we're appealing undoes that. Because while my client won that issue on evidentiary grounds, with the entry of the final judgment, the judge has now stripped him of any decision-making in an area where he previously won on the merits. In addition to the fact that this child is not suffering substantial harm. Now we go 11 days later, after the judge explained this to the mother. 11 days later, mom comes back to court and files round 6. She repleads everything that was just litigated. Mask, vaccination, a lot of COVID-related stuff. I outline it. 2/3 of her allegations were on the issues that had just been litigated and resolved on a substantive basis. There was no issue that she raised except for one, and I'll come back to that. It was a minor issue. I forget what it is off the top of my head, but in her deposition, she expressly said she wasn't litigating that any further. So that was the only new allegation. I think, it was a right of first refusal. Of all the allegations in the complaint that takes us to the judgment that's on appeal right now, everything had previously been relitigated. The only thing that hadn't been was that Dad had not offered Mom a right of first refusal on one occasion. And as I said in her deposition, she said, I'm not pursuing that anymore. So every issue that she pursued in the trial that led to this judgment had previously been litigated. Leading up to the trial, my client, so let me back up. Trial was originally set for January 13th, it was 11th or 13th, 2023. The discovery cutoff, including all disclosures of experts, was set by court order as January 4th. Nothing unusual about that, because typically by the time of the pretrial conference, most judges' orders say you can't disclose anything else, you can't add more to the case because we're heading into trial. But on January 5th, a day after the discovery cutoff, the court ordered that the guardian could retain an expert. And the order that she entered allowing the guardian to retain an expert said that mom or dad can also hire an expert. Now, one of the things I point out in my reply brief is dad is not financially well off. He is strapped economically. The judge ruled on that and ordered mom to pay dad $5,000 to equalize it so he could retain, among other things, an expert. He didn't get the final payment on that $5,000, and this is in the record, and it's in my reply brief. He didn't get payment from mom on that until, I believe it was July 2nd. Now, I'm saying dates, and I want to say for the court, I could be off a day or two on the dates, so I don't think anything I'm going to argue hinges on one day or the other than the fact that January 4th, 2023 was the discovery cutoff, but January 5th, the judge allowed the guardian to retain an expert and said the other mom and dad could as well. Here's the other thing that
Making a ruling like that, again, within the trial judge's discretion.
Here's the thing. In the context of when it affects the framework of trial, then my argument is no, and the U.S. Supreme Court has said that as well. The other side argued in their answer brief that a lot of this was harmless error. But harmless error only applies to certain process rulings by themselves. And, by the way, even harmless error requires the party asserting that it was harmless to prove beyond a reasonable doubt.
Well, before we get to whether it's error at all or harmless error, my question really is, a trial judge sets all kind of deadlines. You have to have your expert witnesses by this point, you got to exchange exhibit lists by the day before Christmas, and you got to do this by Valentine's Day. And then the parties come along, it's like, well, okay, we can push that back a couple of days, or we can do something else. You're supposed to have your expert, guardian wants an expert, okay, everybody can have a similar expert if they want.
You said the parties come along. That's not what happened here, though. Dad opposed the guardian getting an expert because discovery had closed. The judge allowed it over father's objection. And then, in an apparent concession, the judge said, well, dad can hire an expert too.
Mr. Green, I've never heard you argue or even mention the words best interest of the child at this point. So the trial judge is the one who lives the day in and day out of these cases. We do not. We never come face to face with the parties and the family law circuit court. We never come face to face with the minor who was stuck between the battle between the parents. But you mentioned guardian ad litem. The guardian ad litem was appointed for the purpose of and has as its main concern the best interest of the child. You would agree?
That is the goal of a guardian ad litem. Yes, I would agree to that extent.
And the guardian ad litem was focused on the child and trying to provide the court with, based upon their interaction with the child, one-on-one with the child, to the exclusion of the parents, correct? The parents are not part of the relationship between the guardian ad litem and the child is exclusive to the two of them. The guardian ad litem is representing the child in front of the court, correct?
No. An attorney ad litem is representing the child. A guardian ad litem is supposed to represent the best interests of the child.
Sure. And providing that type of evidence to the trial judge, correct? Because the trial judge cannot be one-on-one and delving into the environment that the child has to live in based upon the conflict between the parents.
They're supposed to, yes.
Okay, well, do we have any evidence that they didn't do that in this case?
I haven't made that part of my argument. You know, we have to choose what we're going to present to the court on appeal, and that has not been part of my argument. But if you were to ask me, you want an anecdote? Yes, the guardian was aligned with mother. The guardian, every time we went to a hearing, the guardian was huddled up with mom going into it. Every time we ended a hearing, the guardian was huddled up with mom coming out of it. The guardian never came over and took that fair and balanced approach with us.
And what you're
Never.
arguing now is not in the record on appeal.
I'm answering your question, but it is not in the record on
That's
appeal.
not in the record on appeal.
It is not.
So how was it that the judge, in allowing an expert to be retained for the guardian, outside of the discretion that the trial judge should have to make sure the trial judge, who is in the trenches and comes face to face with the parties, is not presented with evidence and information sufficient to make a ruling as it concerns this child's well-being?
Because if we need an expert, then the expert should be appointed, not the guardian. The guardian was diagnosing my client with mental and emotional problems he clearly did not have. And when the judge allowed me to get a psychologist, the only psychologist who had any active evaluation and investigation in this matter, Dr. Bob Evans, the judge allowed me to get an expert and to do a psychological evaluation of the father because the guardian kept diagnosing him with mental disorders. And when Dr. Evans' report was filed, within days, the trial judge struck it and said, "You're not going to talk about that." That is improper.
Was the guardian ad litem allowed to testify at trial about the supposed diagnosis, or was she prohibited from that?
No, she was allowed to. And I have a Daubert motion where I moved to limit her only to observations. She is not a psychologist, and I moved to limit her. I also moved to
That
strike.
motion was not granted. The judge, you're saying the judge permitted her to testify, the guardian ad litem to testify that your client had this psychological problem and that and this other psychological problem?
The guardian didn't ultimately testify to that, no. But the guardian.
Why? Because she didn't choose to, or because the judge told her she couldn't?
This is not in the record. You know, I try my best. I do trial work as well as appellate work. I try to give you
Not
as
in
much
the
as
record,
possible.
then it's not in the record, so you can move on then.
Okay. But there is a reason, but not in the record. But she was diagnosing the guardian alienation that she was not qualified to diagnose. That's what a psychologist is there to diagnose. And the only psychologist that was involved who had any investigation or evaluation was Dr. Evans. So she struck
Is
his.
that proper, what his testimony would have been?
Yes,
There is.
there is.
Okay, it's in the record.
It is in the record.
Okay.
So she struck his evaluation the minute he showed that the guardian's diagnoses were incorrect, that there was no foundation. In fact, his report, which is in the record, says that these diagnoses are so off the mark, I have to wonder at the motive of the person who's lodging these accusations against the father. That report got stricken. I'll tell you why it got stricken in my view, because it now substantially helped father. I asked to have my expert, whom I was told I could retain. There's an order that says the parties can retain experts themselves to support their positions. I retained Dr. Evans, and he wanted to speak with the child for a 1-hour interview,
You've got about 2.5 minutes left of your rebuttal time. You can use it, it's your time, use it however you want to. But
The judge refused to allow him to speak to the child, and the judge allowed Dr. Day to offer professional opinions, and I cite some of these, I quote some of them in my reply brief. So Dr. Day had no personal knowledge of the facts of this case. She hadn't done an investigation or evaluation, but she's offering professional opinions, which is in violation of Daubert. The guardian is diagnosing alienation, which she's not qualified to do. The trial judge was preventing me from having a psychologist come in and talk to the child to determine if there's alienation, and I know why she did that. Same reason she struck his psychological evaluation of my client, because it showed there was no basis for that. But I go back to this, even if the guardian was permitted to talk about alienation, and I think she could in terms of observational testimony, she just couldn't say it's alienation, because that's a diagnosis. Even if she were allowed to do that, and she was allowed to do more, but even if she were allowed to do that, that's not necessarily improper. But what is improper is barring my expert from talking about that and contradicting the guardian ad litem. And that's what the child judge did too. And she did it because she knew by my disclosures that Dr. Evans was going to contradict the guardian ad litem. And she didn't like that result. I've got 1 minute and 7 seconds left, so if you have more questions, I'll answer them, but I guess I'll save that other minute for the rebuttal.
Okay.
Thank you, Judge.
May it please the court, Mike Brownlee, I'm here on behalf of the appellee, former wife. Your Honors, let's bring it back into focus here a little bit. This is an appeal of a modification that allows former wife exclusive decision-making over medical decision-making and educational decision-making. Nowhere in the briefing is there any sort of challenge substantively to either of those decisions. There's no argument there was a lack of competent substantial evidence for them or anything else like that. There's a hodgepodge of allegations of arguments that purport to amount to due process violations. They don't. As Judge Edwards was insinuating, these are all discretionary decisions that the trial judge in the trenches is making in difficult circumstances. To underscore the idea that there was no due process violation, I mean, you heard Mr. Green came up and said part of his background of the case was discussing how the judge granted, repeatedly the relief that former husband was requesting. The trial judge ordered former wife to pay for an expert for the former husband. The trial judge rejected much of Baum's requested relief, as well as the GALs that went against former husband. The trial judge relied on Dr. Evans, former husband's expert witness, more so than any other witness, and that comes right from the final judgment that's on appeal. I think this is not a due process problem at all. This is a disagreement with discretionary decisions made by the trial court. We filed, I think, a 65-page brief, so sorry about that. But I don't want to sit up here and repeat everything we argued in the brief. So, but of course, happy to answer any questions the court has.
Thank you.
Thank you, Your Honor. Appreciate it.
Very briefly, since that's all I have, Dad was entitled to present his case. He was entitled to present evidence in contradiction of the guardian ad litem's testimony of alienation, which he wasn't qualified to give anyway. That's a psychologist's diagnosis. The judge hamstrung him at every step of the way. In fact, her rulings say if she determines there's alienation, then we'll get to that. But to get there, she's listening to the guardian, but not allowing Dad to present a psychologist who could have talked to this issue. Additionally, as I said, she barred the psychologist from offering a range of opinions that he was prepared to do and that are proffered in the record. She barred my expert from talking to the daughter for a single hour and then granted their ore tennis motion to have Dr. Piddington talk to the child for 6 hours. We are entitled, my client is entitled to make his case and rebut and respond to the evidence, and the judge hamstrung him in that process. And I see that my time has expired. Thank you.
All right, thank you very much. Y'all didn't get to hear from me before. I know you're just dying to hear. I wanted to be a rock and roll star, but I couldn't sing, play an instrument, or dance, so I decided I better go to college